I'm Steve Schillig, the moderator, the director of the Small Business Development Center, headquartered at Kent State University, Tuscarawas. For those that are not familiar with the SBDC, we provide confidential, no-charge consulting in areas such as marketing, food service, leadership, finance and accounting, QuickBooks and bookkeeping, computer technology, HR, and so relevant, but patents, copyrights, and trademarks, which is what we're talking about today. So we have muted everyone for our speakers' benefit. If you have questions, please use the chat room. Jake has encouraged questions for this session, so don't hesitate to ask. Great opportunity to get some additional information that may not be covered or may not be specific to what you're looking for today. So the chat room can be found in the ribbon below your screen. It may also be up in the upper right-hand corner. I guess they move it around from time to time to confuse the moderator, but just hover your mouse over to read show conversation, and at the end of the session, we'll go through the chat room and answer any and all questions that we can. We wanted to offer this workshop to provide some really relevant information for small business owners that are either reopening, restarting, or maybe even repositioning their business through these very challenging times. And with that, I'm very pleased to have on the call today Jake Ward. Jake is a registered patent attorney. He was admitted to practice before the United States Patent and Trademark Office in the state of Michigan and before the United States District Court of Eastern District of Michigan. Mr. Ward is also a registered Canadian patent agent, non-resident, admitted to practice before the Canadian Intellectual Property Office. Mr. Ward is the founding partner with the law firm of Ward Law Office in Tiffin, Ohio. His practice consists of preparation and prosecution of patent applications in various technical arts, including the chemical, mechanical, and electrical arts. Mr. Ward also prepares legal opinions in relation to patentability, infringement, patent validity, and freedom to practice. He received his Bachelor of Science degree in biochemistry from the University of Dayton and his Juris Doctor degree cum laude from the University of Toledo College of Law. At the University of Toledo, Mr. Ward was also awarded a certificate of concentration in intellectual property. Mr. Ward also a materials chemist for several years at the Cooper Tire and Rubber Company in Findlay prior to starting his legal practice. He is also the founding author of the legal blog Anticipate This, which provides light and humorous commentary on the practice of patent law, trademark law, and science and technology. He's an adjunct professor at the University of Toledo, and before we got on the call today, he expressed his desire in teaching and educating, so we're grateful to have him today. And probably most important, Jake serves as an advisor for the Small Business Development Center, which means he is available for direct consultation for the clients of the SBDC, so certainly take full advantage of his experience and knowledge. This session is being recorded. The slides will be emailed to you at the conclusion of the session. And at this time, I would like to turn it over to Jake.
All right, Steve. Again, thank you for the introduction, and also thank you to the SBDC, you and Deanna and Mike, again for inviting me to come in here today and to speak on topics like trademarks, which are near and dear to my heart. Hopefully, everyone should be able to see the slide deck here, and as Steve was saying a moment ago, we'll go through these slides. I don't imagine the slides themselves will take up the entirety of our time here over the noon hour, so there will be time for Q&A here at the end. So with that said, we'll get started, and please hold your questions, and we'll get to all your questions here at the end of the webinar. So, you know, every time I come out and talk about intellectual property, I always use this slide as one of my introductions. You know, what is intellectual property, first of all? You know, sometimes you hear the abbreviation that the attorneys will throw around IP. There is, if you look at this slide, a a legal definition from Black's Legal Dictionary up there, which I don't even bother reading anymore. When I give these webinars to entrepreneurs and inventors, my goal is to really break it down and to make it practical so that you can take it back to your respective businesses and projects, and be able to apply what you've learned. So, in this webinar, we're going to give you certain rules of thumb, some pointers maybe to look out for, as well as some practical advice. When we talk about intellectual property, there's basically 4 different types of intellectual property that we generally refer to. Those are oftentimes put into 2 buckets: not patents and patents. The not patents bucket, trademarks is what we're here to talk about today. So again, any of your trademark questions that you may have or maybe thinking about, you found the right place. That's what we're going to be discussing. We do actually have another webinar coming up next month relating to copyrights, and which is another type of intellectual property. Trade secrets is also another type of intellectual property that we'll sometimes speak about. And then obviously patents, which is what most people think of when they think of intellectual property. So those are the 4 types of basic IP, and we're here today focusing on trademarks. So now we know what IP sort of generally is. The next slide is all about why should we care. This number here, I'm sure it's outdated, but the point is not exactly what that number is, but just the magnitude that we're looking at. Certain economists have analyzed or studied this question of value of intellectual property over time. And this was a number that I grabbed from a report many years ago. Some economists have estimated that if you take the sum total of all intellectual property value, you're roughly looking at $7 trillion. So that's a lot of zeros, right? This underlines the importance of why we care about intellectual property. Why do we talk about it? It's because it is a form of property, or it's very like real property in that it has an inherent value. It's also worth mentioning, almost every business has IP in one form or another. And so understanding that can allow you as an entrepreneur or business owner to take advantage of your IP, or at least know that you can leverage it in certain ways. Coca-Cola is one of my favorite examples. If we were doing a presentation in person, I may have brought with me a Coke bottle or to show as a handy dandy IP demonstration tool. But very similarly here, Coca-Cola, some economists have estimated that company holds in intellectual property more than $70 billion of value. What does that mean? Well, if you were to take that company and were to strip away everything physical from it, so you take away all their inventory, you take away all their equipment, you take away all the buildings, right? Anything tangible, strip it away down to nothing but with the IP, the trademarks, the patents, the trade secrets. That company is still worth more than $70 billion. So again, illustrates the point. That's why we care about intellectual property. So we know what IP is generally, and we know why it's important. But why trademarks? Why are we talking about trademarks specifically? So I'm a patent attorney. Classically, I do a lot of trademark work these days as well. About 50% of my business is trademarks. But I like to say patents are great, but for entrepreneurs and startups especially, the trademark can sometimes be the most valuable asset initially. Not all businesses have patents. Not all businesses are dealing with inventions, but almost every business has a brand. It has a name. It has something it's going to be recognized as or by in the marketplace. So that's why trademarks, I think, are very important to talk about. They sometimes get overlooked in this whole question of intellectual property protection. But whether you're venturing, meaning you're actually going out there and starting your business, or you're licensing, which means you're just pitching your concept to another company and taking a royalty, selecting a good, strong trademark is important. So we're going to talk about how to do that here today. A strong trademark is going to generate excitement about your invention and about your product. It's going to separate you and distinguish you from your competition, which is really one of the most important legal aspects to the trademark law. Most importantly, doing some due diligence up front and picking a really good trademark is going to prevent you a lot of legal headaches further on down the road. We sometimes talk about receiving what are called cease and desist letters a couple years after you're up and running. Now, when you're out there and the trucks are painted and signage is up, and all of a sudden someone comes out of the woodwork and you find out, oh, they actually had the rights to this for years before me. It puts you in an awkward position, where you have to do a mea culpa and again, incur the expense of rebranding. But maybe some good due diligence up front would have helped you prevent that situation. So anyways, selecting a strong trademark is important, and that's why we're going to be talking about it here today. Before we get into how to select a strong trademark, just some basic points, bits of information to keep in mind. This rule of thumb that I want everyone here who's listening today to remember. What is a trademark at its most basic? Basic form, it is nothing more than a source identifier. It's something that distinguishes your goods or your services as coming from you and not from your competition. Generally, when we talk about trademarks, what comes to mind most often is the word, the name. So Coca-Cola, as an example, distinguishes that brand of soda from, let's say, Pepsi-Cola. Okay, but I encourage people when thinking about trademarks, think about your trademarks more broadly. It's not just the name of the business or the product or the service. But it can also be other identifying features. And most commonly, we're talking about things like logos, so artwork. For instance, if I were to put my shoes up on the table here, and you were able to see, oh, all right, Jake's wearing tennis shoes today, and he has a particular swoosh on the side of his shoe. You know where that shoe came from, the source. It is Nike, right? Without having seen the word Nike. So logos can in fact serve as trademarks apart from the words and can be very valuable. We oftentimes talk about sort of exotic marks, things like sounds and smells and colors even can all serve this important source identifying function and therefore be trademarks. So when you think about your products or your services, think about your trademarks broadly. Yeah, absolutely, it's going to be the name, but it could also be these other things, including product configurations or packaging even. Some other interesting points here relating to trademarks. Generally, trademark rights are interesting because a certain amount of rights attached simply by using your trademark in commerce. It's what we call common law trademark rights. And a lot of times people, when they first hear this webinar, this information, they're surprised to learn that if you are already out there selling your goods or your services underneath a certain name or trademark, you can actually have the right to use the TM symbol next to it. Generally, it's in the upper right-hand corner of the mark, but that's just business convention. Legally, it doesn't have to be anywhere in particular. But the TM symbol can be used immediately without having sought any registration. That TM symbol gives warning to the public. It says, listen, I believe this to be mine. I'm fencing this off. I'm claiming a trademark interest in this. Now, even though you have automatically through common law use the right to use the TM symbol, we generally do recommend that you seek registration if the brand is important and the business is important and multi-state, meaning you're selling outside of just your local town, perhaps. What happens with national registration is you get nationwide rights. That's one drawback or limit to common law use is the rights really only attach where you've used the mark commercially. Not so if you register. If you register, not only do you get the ability to use the circle R symbol, and that's what that means. It means it's also a trademark, but yet they've taken steps to register it. But then you get the nationwide coverage. And it doesn't necessarily matter if you haven't sold yet into Virginia or California or Wyoming. You will be able to claim the rights there and prevent people from sneaking in and adopting the same or similar marks for same or similar goods or services and basically riding your coattails. So that's why registration is generally encouraged, even though you do have a certain amount of common law rights simply by using the mark in commerce. Another interesting factoid here about trademarks is that the first to use the mark has what we call priority, meaning they have superior rights to anybody who comes later. Now, what's interesting about that is while you may be able to establish superior rights in a common law manner in a certain region, maybe in Ohio where you've sold, if someone comes along and registers the mark, they may be able to box you in, in which case they have superior rights elsewhere, but you only could claim your superior rights in that region where you were selling previously. So it's another interesting sort of facet of trademark law, and another reason why we encourage registration sooner to avoid this sort of being this scenario where you're boxed in and are limited in how you can use your trademarks moving forward. Finally, last bit of information here on the screen. This is one of the reasons why I love trademarks. I think they're such a powerful form of intellectual property. The rights last potentially as long as you continue to use the mark commercially. You can claim the trademark right. This is very different from patents, which if we were talking about patents today, I would tell you they're good for about 20 years. It's different from copyright. Even though copyright has a very long term, it is still finite. Trademarks can last potentially forever. So again, very long-standing, strong right. And again, it's nothing good for a business to secure if it's important to them. All right, this is my favorite slide in this entire webinar, so we'll take some time going through it. Remember I said at the outset, one of the things I want you to learn, take home from this webinar is how to pick a good trademark, select a strong mark. And that's what this screen is all about. So if you look at the screen, there's a sliding scale from left to right, with Kodak being on the far left and IBM being on the far right. The strongest and best trademarks that you can select for your business are what we call fanciful or coined marks. What do we mean by that? Well, these are trademarks that are made up. They have no dictionary definition. Kodak is my great example of that. Absent its connection with that company, it has really no meaning. A couple of good reasons why you should consider picking a fanciful or coined mark. First of all, you're not likely to cause confusion with anybody else in the marketplace. If you're truly made up, it's going to be able to gather a whole lot more business and a consumer recognition much more quickly if it is truly made up and not going to be confused with anybody else. More likely than not, if it is made up, coined, or fanciful, you're going to be able to register it, very easily in that case, which again, as we talked about earlier, helps secure mark. A choice with or coin mark. One step in strength, but still marks they're very strong and can be selected with some confidence, are what we call arbitrary trademarks. Apple is always my example of a great arbitrary trademark. 50 years ago, if I was giving this webinar and I raised my hand and said, "Hey, I work for the Apple company," what do you think I would be selling? And most likely it would be fruit, right? But the fact that the Apple Computer Company began using the term Apple, which was found in the dictionary, but using it in an arbitrary sense with respect to computer technology, makes it a very strong trademark. And absolutely, Apple is registered many, many different ways at the trademark office for that reason. So best marks you can pick are fanciful or coined. Very good marks also are these arbitrary marks. So actual real words, but used in a different way. Going down one step further on the screen, but marks that can still be registered are what we call suggestive trademarks. I can tell you a lot of large companies, there's sometimes some tension between the marketing group and the legal group. And the legal group says, "Hey, pick a fanciful or arbitrary mark," and the marketing group says, "Well, we want our marks to tell the customer something about what they're buying," right? And a lot of times where they will come to some agreement or compromise would be the picking of a suggestive mark. Suggestive marks hint at what the product or the service does or some quality of it without coming out right and saying it. My example of a mark that I believe is suggestive is Tide. To me, it evokes certain imagery in my mind of water, cleanliness, repeating, right? Without coming out right and saying, oh, it's a detergent. So it's a suggestive mark. And suggestive marks can in fact be registered. They are inherently distinctive. All the way on the far right of the screen here are marks that we call descriptive marks. I'm here to advise you, if you have a choice, try not to pick a descriptive mark. I'll talk a little bit about the example first, and then we'll get into the reasons why that's the advice. But international business machines, what do we think they're selling? It's probably business machines, maybe on an international basis. It's a descriptive mark. It's going to be very weak. The government has a policy where they say, well, everybody should be able to describe what their product or service is. We shouldn't be able to permit people to take that away from all other businesses. So if it's merely descriptive of the nature or quality of the product or the service, it should be something everyone can share and can use. One trick of the trade, perhaps, maybe you are leaning towards a descriptive mark. One trick of the trade is to perhaps use an acronym. You take international business machines and you shorten it to IBM. Now you have a very good, very strong trademark, something that's perhaps fanciful and inherently distinctive. Another trick of the trade, if you're sort of leaning with respect to your business, having a descriptive sort of name or mark, is you can take parts of it and sort of mesh them together. Again, you're making fanciful marks, in a certain sense, but there's a nexus or connection to that nice description that maybe you prefer. Descriptive marks, they can be registered, but it is more difficult and certainly going to be more expensive to do that than if you pick a fanciful or arbitrary or suggestive mark. So that's why if you have the ability, choose a mark that's over on the left side of the screen rather than one that's probably over on the right side of the screen that you're looking at. Last bit of information here on this slide. Like I said, this slide is chock full of good advice. Is down at the bottom here, where we talk about something called genericism or generic marks. Generic marks are words that are simply the goods or the services. It's just not necessarily describing it. It's the name for what that thing is. And similar to descriptive marks, there's a general policy in the government that we don't want to let people reserve the name for the thing itself as being theirs. Anyone else who's selling it should be able to call it what it is. And the important part to this slide here and this advice is it has some bearing on how you should use your trademarks. Trademarks, if you go back to like third or fourth grade English class, they're really nothing more than modifiers. So like adjectives or adverbs. They are something that modifies the noun or the verb that follows it. So when we are talking about trademarks, the trademark should usually in your marketing or website be followed by the product or the service. So let's say I'm selling widgets and my trademark is Jake's. So Jake's TM widgets. That's how I want it to be described on all my products and packaging and websites, etc. Jake's TM widgets. I want to avoid saying I'm selling Jake's or come buy Jake's from me or here's some Jake's. Would you like some? I am selling Jake's TM widgets. The reason why this proper usage of a trademark after you selected it is important is because if you misuse your trademark and if you become very popular, you can in fact run the risk of losing your trademark rights over time by the general public coming to understand the product as being synonymous with the mark and the name. Some historical examples I have on the screen here, aspirin. Aspirin, you go back 100 plus years, the Bayer company, Bayer, owned aspirin and was selling aspirin, and aspirin was considered their trademark. Through misuse, through public perception, the public started purchasing aspirins. They started asking for aspirins. Pretty soon, all of Bayer's competitors could also sell their brand of pain reliever as aspirins. Again, the mark became generic and the Bayer lost those trademark rights. Cellophane's a good example. Escalator's a good example. If we were doing a live webinar, I might at this point, ask for other people to pitch in and give me their thoughts on current modern marks that might be generic, but I can give you, or might be at risk of becoming generic. But I can give you a couple that come to mind right now. Kleenex, I think, is a modern day example of a mark that's at risk of becoming generic. If you've heard any Kleenex commercials in recent memory, you'll be quick to notice that they are avoiding saying "pass me a Kleenex" or "come buy Kleenex." What do they say instead? Purchase Kleenex brand facial tissues, right? So Kleenex brand facial tissues. Why are they doing that? Well, it's because you can guarantee their army of lawyers talked with their army of marketing folks and said, listen, guys, we need to respect our trademarks. We need to use them correctly. Otherwise, we're going to run the risk of becoming the next aspirin. Another modern day example, Google. It's probably a good example there. And there has been litigation on that. Google has survived that litigation. They still can claim a trademark right in Google. But how many times have you heard somebody say, "Well, I Googled this," or "Just go Google that"? Well, that's misuse. You should do a search using the Google search engine is what you should be doing. And I'm certain that they've had conversations internally about how to market to make sure they respect and preserve those trademark rights. So to wrap it up with this slide, it's all about picking a good mark, picking a strong mark, something on the left-hand side of the screen. And then once you select it, make sure you use it appropriately. Remember, it's a modifier, and it's always to be followed by the goods or services in your advertising when using your trademark. Because picking a good trademark is highly important, that sort of is a really good segue into this slide, which is about doing searches. I can tell you that there is no legal requirement to do any searching whatsoever before filing a trademark application at the U.S. Patent and Trademark Office. But while being optional, we generally do recommend it. I mean, I think it's all about doing your due diligence. And whether or not you pay a professional to do a search, or if you just do some informal searching yourself, I think it's a good idea. What you can do if you want to, sort of take a stab at it yourself is you can actually check out the U.S. Patent and Trademark's federal trademark database, which is at tmsearch.uspto.gov. And that gives you a sort of a very high level way of sort of just searching the register for similar marks. When you are considering trademark search results, it's important to remember that you're not only just looking for exact spellings and hints, right? The whole point of the trademark law is to prevent confusion. And so when we look at this question of registrability and usability for a proposed mark, it's a balancing test. So we look at not only how close the marks are, but how close are the goods and services. Two companies can own identical trademark rights in the same trademark, as long as the goods and services are completely different. I sometimes will use the example here of Jake's. Maybe I'm selling Jake's TM pizza, but you want to sell Jake's TM tennis shoes. Well, that's probably okay, because no one's going to be confused to go to the shoe company thinking they're getting pizza or vice versa, right? Where you run into conflict, though, and concerns would be maybe I'm selling Jake's pizza, but you want to sell Jack's lasagna. It's lunchtime, so I'm hungry, and we're talking about Italian food here. But you can absolutely imagine in that case, someone might be confused and go accidentally to the Jack's lasagna company thinking they're getting Jake's pizza or vice versa, right? The marks, while not the same, phonetically similar. The goods, while not the same, they're both Italian food. So when picking a trade or when searching a trademark, those are the sorts of considerations to keep in mind. Yes, it's great if you don't find the exact spelling, but if the spelling's a little bit off, but the goods or services are still closely related, it's probably a mark to avoid. There's a lot of text on this next slide, and like Steve said at the outset, everyone's going to be given copies of these slides, so I'm not going to read this verbatim. But this slide is all about how to actually complete a registration at the trademark office. A couple high-level points that I want to talk about here. With trademark rights, one of the interesting aspects to it is you actually don't have to have started using the yet to file an application. Obviously, you can, if you've adopted the trademark and you've already started selling your goods, then you can file on what's called a use basis. But you can also plant your flag at the trademark office early. So, and this is great for entrepreneurs and startups where you want to preserve your rights without having yet started your sales. And you can file on what's called a good faith intent to use basis. In the biz, we call these ITUs. So know that you can, in fact, do that. The examination is very similar in both cases. You're going to be assigned to someone called an examining attorney at the U.S. Patent and Trademark Office. They are judge and jury over your application, and they will do searches similar to what I was suggesting you might consider doing yourself to see whether or not you're likely to cause confusion. This is a process. It takes on average between about 3 to 6 months to receive what's called a first office action, which is the initial assessment on trademark registrability. There's almost always some back and forth with the trademark examining attorney. Sometimes it's minor clarifications. Sometimes they raise issues and other registrations that you have to explain how you're different from those. Once you reach an agreement, though, with your examining attorney, you are then published for a period of 30 days. That gives the public an opportunity to chip in, and if anyone has any concerns, they can raise those and oppose. It's fairly rare that happens, but it does happen. If no one opposes, then you will receive a registration certificate in due course if you filed on a use basis initially, or if you filed on the ITU basis. At that point, you just have to show that you've been started using the mark. You generally get up to 6 months from that allowance to show use, and that's extendable in 5 6-month increments. So if you're adding that all up in your head, you get over 3 years effectively through extensions to show that you've started using the mark to complete the registration at that point. Once the registration is completed, although I said, you might recall I said earlier, trademarks last potentially forever. That's true. There is a regular renewal requirement associated with the actual registration. So there's a declaration requirement in the 5 to 6 year window where you have to show that you're continuing to use the mark at that point. But thereafter, it's every 10 years from the initial registration. You have to pay a renewal and show that you're continuing to use the mark. If you pay that renewal and show you're continuing to use, the registration will continue to last indefinitely until you quit making those payments and renewal requirements. And by the way, there are costs on this screen. Obviously, those are subject to change. And in the case of the government fees, you'll notice there's 2 different government fees there. It's because the government does have what's called a trademark ID manual. So if you were able to pick a product out of this manual description, a goods and services description it's called, then they give you a little bit of a cost break. Sometimes, though, you can't do that. Your product may be new to the market. It doesn't really fit into any predefined bucket all that easily. Well, they let you use a custom description. They just charge a little bit more for that. That's the reason why there's 2 different sets of government fees at that point. Okay, like I said, I knew we were going to have plenty of time here for Q&A. So final IP thoughts, just sort of tying everything that I've talked about here together before we open up for questions. I want everyone to remember that securing intellectual property in general and trademarks specifically involves a process. It's not something where you simply file some paperwork at the trademark office and you'll walk away. There's always work that must be done to these applications forward to their eventual issuance or registration. There's almost always some minimal fight, at least, involved in making sure that the government and the trademark examining attorney agrees with you that you deserve the registration. So you should expect that. On average, I could say for trademarks, like I said, it takes maybe 3 to 6 months for that first office action. You might expect roughly 9 to 12 months total to complete a registration. So it is a sort of a long-term endeavor. If you do file on the ITU basis, like I said earlier, it could be up to 3 years before you actually have the registration in hand. So remember, it is a process. That being said, too, IP and trademark specifically can be a very powerful business tool. There is never a requirement, no legal requirement whatsoever, to ever file for a trademark, a patent, a copyright. But hopefully you understand and can appreciate from the information given here today, there's good reasons to try to fence off this property that you own as a business or an entrepreneur, to prevent people from trading on your goodwill and riding your coattails. You know, it also does serve that's important source identifier function, right? So having the registration will prevent people from registering or using very similarly looking marks in the future. Relative to copyrights, patents, and trade secrets, like I said, we didn't really talk about these here today, but those are other forms of IP, other types of fences you can consider building around your intellectual property to try to ward off competition. I do want to mention here, because a lot of times people don't think of this with respect to trademarks, but trademarks, just like patents, can in fact be monetized by licensing or assignment. So most classically, trademarks are used on products that you're selling yourself, but you can consider also licensing your trademark rights to others. So if you have a particular line, maybe you want that you're selling at a particular brand, and you may be looking at an exit strategy. Maybe there's a company that would be better suited, already has channels of trade in particular markets, and they could sell perhaps millions of the widget, whereas you're only selling hundreds. You could consider a licensing arrangement at that time. And if your trademark is a good trademark, it may be the most important facet to that business and therefore the most valuable thing to license. So just understand that, know that is an option and a way of monetizing your trademark specifically. So with that being said, hopefully everyone here today can now take this back to your respective businesses and projects, recognize what your trademarks are. Remember that rule of thumb, it's a source identifier, and know that there are ways of fencing it off and sort of leveraging those rights to make your business successful. So with that being said, Steve, I will be opening it up for questions here at this point.
Very good. Well, a couple quick things. One is a reminder, November 5th is the copyright presentation that Jake's going to do. That'll be at noon as well, so mark your calendars now. Secondly, this was very valuable for me. We do get a lot of questions, inquiries about trademarks, patents, copyrights, etc. So having some distinction for me, but I know that I will be quickly referring them to the experts like Jake. So, and then finally, third, I will never purchase another product off the shelf without giving some thought to the original mark that that company established. So thanks for all the valuable information. We do not have any questions in the chat room. I would say that it's a small enough group that if you have a minute or two, Jake, maybe they could ask you directly by unmuting themselves, and we'll try that. Maybe that'll be better than them typing a question in. So if those that are on the call would like to ask a question, unmute yourself, and I'm sure Jake would be happy to help you.
Yeah, feel free. Any questions from the audience? And I can say too, if you don't have a question about trademarks, I'd be happy to field, sort of any patent or copyright questions that you might have too. Burning interest in patent law, perhaps.
I would take this that you were very thorough in your discussion, and I found your early slide about Tide and a couple of the others, Coca-Cola, were very educational for me and brought some perspective to this whole IP world.
Yeah, like I said, Steve, when I historically have come out to do seminars in person, I bring with me that Coca-Cola bottle because it's a great demonstration tool. I mean, it has all forms of IP in there. It's got the trademark Coca-Cola, in writing, on the label. It also is really good to sort of illustrate that point about that I was mentioning, that trademarks are not just words. I mean, it can be things like product configurations. Most people, in this day and age, if they saw a bottle of Coke, a glass bottle, sitting on a table without even seeing the label, they could probably guess that it's a Coke bottle. Well, why? Well, it's got that very distinctive profile or look associated with it. So product configurations can absolutely serve that source identifying function. That can sometimes be extremely valuable. I personally have clients who have products that they've been selling for over 100 years, and there was patents perhaps on various aspects of the products 100 years ago. But patents are finite; they're only good for 20 years, and those patents then expire. But the consuming public has come to recognize that particular shape or look of their product or their packaging as coming from them, and so that's given them a way of fencing off and sort of protecting them from a lot of these, sort of cheap knockoffs and imports that may be coming in from overseas.
Sure, sure. We do have a question from Phil. When is a good time frame to seek registration for a logo mark?
So that's a good question. My general advice is if you really like the mark and if you're planning on using it, and if you think you're going to be able to start commercializing within the next few years, so again, 1 to 3 years, I at that point say you're comfortable filing that ITU application. All right. And the important thing about that is it plants the flag at the trademark office early. So if anyone else comes in with a similar mark later, doesn't matter. You're there first and you block them. Right. And you're going to have up to 3 years through those extensions if needed. And you don't have to wait the full 3 years. I mean, if you're commercializing in 6 months, then you don't have to worry about the extensions. But you know that those are available and you have up to 3 years where your rights have been preserved and you're blocking other people from registering similar marks during that time.
Okay. This may be way off course and not relevant to today's conversation, but when I'm watching a movie and I see a box of cereal, Captain Crunch, whatever, on the table, is the producer, director paying for that? Is that
product placement is what we're talking, right? Yeah, and that's very much done intentionally, and I mean, you can guarantee there's so much IP involved in the movie and TV making process, right? And you can guarantee that there are contracts in place permitting the movie studio or the television studio to display those goods, display those products, especially the trademarks. There's going to be almost certainly a payment that's being made to the movie studio. That's why it's just another form of paid advertisement by the business. But yeah, it's all heavily IP related still in that case.
Very good. Well, again, I think you did such a good job of walking through the information that we don't have any questions. I can't thank you enough, Jake, for joining us. This is a subject that comes up often, whether we're talking to a newbie, a startup business, or an existing business. So, and we have referred clients to you over the years, and we've been very grateful for the support you provided with that. So thank you for that. Thank you for presenting today. Look forward to November 5th. And just a quick thank you to the attendees today. Hopefully you got something out of it. Watch for the slide to be emailed to you shortly. And then on our website, probably in the next week or so, will be a recording. So if you want to listen to this again, you're certainly welcome to, or suggest others go to it that weren't able to be on the call today. But thank you again, and have a great rest of the day.
All right. Thank you all.